Yes, Mr. Kamrami.
Yes, my lord.
Yes.
Lordship, I'd like to mention item number 3, Lordship. Lordship, can you grant me 3 weeks time to file counter?
Item 3.
Lordship.
Okay.
Yes, Lordship.
On the prayer of Mr. Kamrami, Learned Senior Government Advocate, 3 weeks time is granted. to file affidavit in opposition.
May I please, my lord?
Yes, Mr. Nangami.
Lordship, I beg to mention item number 21. Hearing item number 21, your lordship. If this matter can be listed after 2 weeks, my lord.
Okay,
Lordship, no objection.
on the prayer of Mr. Nangami, the learned senior government advocate, listed after 2 weeks.
2 weeks, my lord.
Okay,
Lordship, I also beg to mention item number 22 and 23.
22 and 23.
Lordship, the hearing matter item number 19, I'm not prepared with these two hearing matter. If this matter can be listed next Tuesday, my lord.
What is next Tuesday?
Lordship, that would be 21, my lord.
On the prayer of Mr. Nangami, learned senior government advocate, release the case on 21/5/2024. Okay,
I'm deeply obliged, my lord.
Lordship, I beg to mention item 4, Lordship. I have filed my affidavit in reply. If it can kindly be listed in the hearing in the usual course.
who's for the
Item 4.
government? Who is for the government? Have you received the copy of the reply?
Yes, Lordship.
Okay. It is submitted by the learned counsel for the parties that pleadings are completed and the matter can be listed for hearing. Listed for hearing in the usual course. Okay.
Lordship, I also beg to mention item 14. I have instructions to withdraw.
1/4.
Yes, Lordship, 1/4.
Mr. Santiyamar, the learned counsel submits that he has instructions to withdraw the writ petition. No liberty,
No liberty, Lordship,
no liberty.
no liberty.
Writ petition is allowed. Writ petition is closed as withdrawn. Okay.
Lordship, if, just for safety's sake, if liberty may be granted.
The writ petition is closed as withdrawn with liberty to file afresh. Okay.
Now, Lordship, I also beg to mention hearing item 20.
Yes.
Yes, my research is almost done, but it is yet to be completed. So if it can be listed after 3 weeks, I have taken the counsel of my 11th friend.
So you are the counsel for the petitioner? Mr.
Yes,
Santi?
Lordship.
Mr. Santiyamar, learned counsel seeks adjournment of the case for 2 weeks,
3 weeks,
for
Lordship.
3 weeks. Where is allowed, listed accordingly. Okay.
Deeply obliged, Lordship.
May I please, my lord?
Yes.
My lord, I may be allowed to mention for item number 27 of the hearing list, lordship. Lordship, this matter,
27?
27, lordship.
Where is
Suppli-
20?
Suppli, lordship.
Oh,
If it can be taken up after 2 weeks, lordship.
27.
It
Yes,
was-
Mr. Paul,
It was Passover yesterday. Lordship.
Passover.
Yes, it was
What
passed
day?
over yesterday, lordship.
Ah,
But today, I'm led, in this matter, I'm led by my Subbu Jamir, lordship. So he has some difficulty today. There has been a family emergency, lordship. So kindly grant us 2 weeks' time, lordship, to enable him
Mr.
to.
My lord, a fixed date if given.
Yes. Mr. Tushio Longkumar. The learned counsel makes a mention on behalf of Mr. S. Suppu Jamir.
Yes, lordship.
S. Suppu Jamir. And seeks adjournment of the case after 2 weeks. Prayer is allowed, listed on, give a date. Listed 20th of May,
Me, lordship.
listed on 28/5/2024. Okay.
Obliged, lordship.
Matter. Oh, interim is there, your lordship.
Okay. The interim order passed earlier shall continue till the next returnable date.
Matter.
Okay.
May I place your lordship?
Yes.
Your lordship, I beg to mention item number 6. Your lordship, let the matter become after 2 weeks since I have some difficulties, your lordship.
Let us see. If you have difficulties, let us see. Let us see. Let us see the records.
Your lordship, I've already filed my reply, so let the matter become for hearing.
Is it, madam?
It's a short matter, your lordship. It can be in the admission.
Let us see. Let us see. Let us see. Let us see. Let
Your
us-
lordship, then let the matter become tomorrow, lordship.
Tomorrow is Wednesday. DB's day.
On Thursday, lordship.
I don't know. Okay. Listed again on, what is Thursday?
17.
Is it 16? Listed again on 16/5/2024. Okay.
Much obliged.
May I please, Your Lordship?
Yes, please.
My lord, I beg to mention here item number 18. My lord, here we are supposed to file additional affidavit. However, here we have to turn the affidavit after we are able to get the signature of the client, and he's from paid. So lordship kindly done one week time.
Mr. So-and-so, learned counsel for the petitioner submits that the additional affidavit has been sent for vetting of the petitioner, and the same will be filed in a week's time. Therefore, seeks adjournment of the case after a week. Prayer is allowed, listed after a week. Okay.
Much obliged.
May I please, Your Lordship?
Yes,
I
ma'am.
beg to mention item number 8, 9, and 10. Your Lordship, kindly grant us 3 weeks time to file a reply.
And Mr. So-and-so, learned counsel for the petitioner is allowed 3 weeks time to file affidavit in reply. Okay.
Much obliged. May it please, Your Lordship?
Yes,
I beg to
ma'am.
mention item number 5, Your Lordship.
Uh,
We're yet to file a counter affidavit
on behalf of,
and on behalf of the private respondent number 3, Your Lordship.
respondent number 3.
Yes. Kindly grant us 3 weeks time, Your Lordship.
Let us see the record. The government is also there. Let us see the record.
Government also seeks 3 weeks time to file.
Lordship, government, they are yet to file affidavit, Your Lordship.
Okay. Mr. So-and-so, learned government advocate, as well as MS So-and-so, learned counsel for the respondent number 3, 6 for 2 weeks time to file their respective affidavit in opposition. Prayer is allowed, listed accordingly. Okay.
Lordship, much obliged.
Much obliged.
My pleasure, Lord. Lordship.
Yes,
I beg to mention item number 2.
item 2.
Yes.
Ah,
Lordship, in this case,
pleadings are completed, Mr. Moa,
Yes.
completed.
Yes.
So we can list it for hearing in the usual course. Correct. It is submitted by the learned counsel for the parties that pleadings are completed and the matter can be listed for hearing. Stop. Listed for hearing in the usual course. Okay.
For motion, item number 26.
Yes, ma'am.
Good morning, Your Honor. I'm
Yes.
petitioner number 2 and this is petitioner number
You are
1.
petitioner number 2.
Yes, Your Honor. Your Honor, we just received a reply to IA 58 from the opposite party number 1,
Who is opposite party number 1?
the hospital, Your Honor.
Christian, yes. But ma'am, perusing your application, I find that you have made serious serious allegations
Yes, Your Honor.
against your counsel,
Yes,
which is very serious.
extremely serious,
Yes,
which is why
and,
we want the court to
and-
take action.
You have not impleaded the counsel. You cannot step someone at the back.
I'm not
You
doing that, Your
implead,
Honor.
you implead that counsel because she should also get an opportunity to answer your
And
charges.
she will get her opportunity if
You
you
implead, you
pass
implead.
the order to have her investigated, right?
No investigation before impleadment. No
Okay.
investigation before impleadment. This is very serious.
Yes, of course,
You
it's
are
very serious
alleging
because
tampering of records, forging your
Yes.
signature.
that is a very serious
Yes,
allegation,
that
which
is a
we
very
have
serious
evidence of.
allegation, but I find that actually that
Mhm.
lawyer is not impleaded.
Okay,
You implead,
That's-
we'll give you that opportunity. You
okay.
implead, let the matter come up along with the other items on the next date.
Your Honor, also, if I may, opposite party number 1 gave us the reply.
It's all right, it's all right. We'll record that. We'll
Yes,
record
if I
that.
can just, Your Honor, on April 22, they gave us the reply to IA 58.
Ah,
Right? The very next day, April 23, in the court itself, they took receiving. But today, they've given us a modified version.
Modified version.
Modified version. You see the difference, Your Honor.
Yes, what is wrong, Mr. Council?
a modified version.
What is that
And trying
modified
to take
version?
receiving again, saying that this is their original reply from before. It's not.
You
This
have
is
received other copies of the reply also.
completely different.
Are you in possession of the other copies of the reply?
Yes.
Yes.
This is
Yes,
the
why?
original.
In addition, we have added certain things. That's all.
Pardon?
In addition to that, what we filed earlier.
But you gave us no notice only right now
Yeah.
and trying to take
And
So,
receiving,
you-
saying that
so
this is
what
the
you mean to say
original.
is that these are additional reply?
We have enclosed the clinching proof for there is no negligence at all.
No,
It's
we are not,
completely different.
we are not going into the merit. We are
Yeah.
not going into the merit. We are actually trying to clarify how many reply you have filed. Yes, Learned Council, how many reply you have filed?
Two completely different ones.
Two, okay. So you have received both the copies?
Yeah.
You have received both the
Your Honor,
copies?
they haven't filed this one.
So you have received both the copies?
Now we have at the
Yes,
last
so you
minute.
have
But
received.
is that right, Your Honor, that they
That-
modified the reply at the last minute and trying to get
Your
us to
Honor,
write a receiving
uh,
stating that this is the original one that they gave us last month? Last month. Is that right? How can
Yes,
they?
Mrs. Asa.
With the permission of the court, Your Honor, the first reply, the affidavit which was filed by the respondent number 1 was not accepted by the registry because the case number was handwritten.
Okay,
And accordingly, that was not filed.
okay.
Yeah, subsequently,
Ah,
the petition, the affidavit in reply has been filed yesterday and a copy has been served to the petitioner.
A different version or the modified copy?
Modified copy, but the earlier one was discarded. It was not accepted by the registry and it is not part of the record.
I think, yes. You have received both the replies.
Yeah.
Yes.
It's all
no,
right. You have received both the replies, you will get the
Yes.
opportunity.
Yes.
That is in this IA 65. IA 65,
IA 58. They replied to IA 58.
which is IA 58. Oh, this is IA 58. What is IA 58 again?
IA 58 is requesting for the court to put the prayers back and the doctor's names back.
Okay. Who are the parties in IA 58?
IA 58?
IA 58, yes, Christian. You are for
Respondent number 1.
one. Who is for the government? Who is for the government? Ma'am? Yes. What about Nagaland Medical Council?
They have no counsel till now, Your Honor. Neither does AIMS.
What about Union of India? Mr. Yangarwati? What about All Indian Institute of Medical Sciences?
They also have no counsel, Your Honor.
Whether you have served notice?
Yes, Your Honor, twice.
Let us see the office note. No, in this IA, you have not served notice.
Your Honor, I've served notice on both IAs. Via email, I've served notice on AIMS and on Nagaland Medical Council
No,
twice.
it cannot be via email. It cannot be via email. And no order has been passed till date to serve notice. We'll issue notice. We'll at least see that this Nagaland Medical, this Nagaland. Yes, ma'am, Nagaland Medical Council, is it an autonomous body?
Statutory body.
But otherwise, your lordship, even the IA, the earlier IA is also not maintainable, even the present IA is. also not
No. Well, of course, we'll hear, but no notice has been issued to the
But,
respondents.
Lordship, my humble submission is that before notice is issued, whether the petitioner has made out a case to file an IA or not, that has to be seen. Only if-
No, see, madam, the letters have, whether you have the copy of the letters IA,
I have.
I think this IA, this 58 has to be heard together with 65. It is interlinked. The serious allegation made against
No,
the,
even if a serious allegation is made, your lordship, the person concerned has to be made as a party.
That's what I'm
He has not
saying.
made the person concerned and Advocate Nityo as a party. And even this court will not have the jurisdiction because, Your Lordship, there is a different forum, Your Lordship. They are making a one allegation against the.
See, madam,
Advocate, Lordship.
there is a different forum.
Yes,
You mean to say that if the allegation is proved,
yes.
the Bar Council authority is the right authority? Bar Council is the right authority to take up the case against the person against whom allegation is made.
Your Honor, we
Yes,
have
but-
filed with the
Yes,
Bar
yes.
Council.
Whether this court will take the evidence, Your Lordship.
No,
that
no,
is
no,
the
this
question.
court will not take evidence, but at least this court can hear and then this court can actually direct the Bar Council to take up necessary action. But unless that person is impleaded.
That person should be impleaded as a party, Your Lordship.
No, yes. We issue notice, you take steps on 58.
Your Honor,
Heard?
Your Honor, this court has ordered for notice to be given to Nagaland Medical Council and AIMS via speed post. And we've,
Where is that order?
yes, Your Honor, let me just find it, it's right here. It's order 10-3, sorry, not. Hold on 1 second, Your Honor.
You are referring to the main writ petition.
Yes, Your Honor, order
I
for.
am on IA 58. I am on,
I've given notice, served notice multiple times
heard MS and so.
on both IA
Learned counsel for
65
the
and
applicant in
58.
person. Mr. So-and-so appears for the respondent, learned counsel appears for the respondent number 1. MS V. Socrates, learned additional advocate general appears for the respondent number 2, and 4. And Mr. Yangawati, learned CGC appears for the respondent number 5. Correct? 5.
Yes.
5.
Your Honor,
Stop.
if I may ask, what is the reason that we cannot give digital service?
The
If
learned
the opposite
counsel-
party can service digitally, why can't? I not?
Please follow the directions of this code. The learned
Yes.
counsel for the petitioner shall take steps for service of notice upon the respondent number 3 and 5 by registered post with AD within a period of 3 days from today. Listed after 3 weeks. In IA 65. Third. MS so-and-so. The applicant in person. Mr. So-and-so, learned counsel for the respondent number 1. MS V. Socrates, the learned counsel for the respondent number 2 and 4. And Mr. Yangawati, the learned counsel for the respondent number 5. The applicant shall take steps for service of notice upon respondent number 3 and 6 by registered post with AD within a period of 3 days from today. On perusal of the records, on perusal of the application, this court finds that the person / lawyer against whom serious allegations are made is a necessary party. Stop. The learned counsel for the applicant shall therefore take steps to implead the person / lawyer as one of the party respondents in the application listed after 3 weeks. Okay. If this, what is the connected IA?
58.
And 65, Your Honor.
58.
Number 15 and 16.
This is 65, no? This is 65.
Yes, ma'am. 65.
Where's the men writ petition?
Item 15.
No, men writ petition? Which is item, which is this item in this? IA 58, that IA 58, no?
Yes, yes, ma'am. Yes, yes, yes.
WPC 6/2022 shall be listed along with the present IA. Okay, yes. You implead, after that we will see. You are
Okay.
making a very serious allegation.
Yes, that we
Yes.
have evidence of, including the tampering of court records that
So
was
at
in the
least let us
registry.
hear the other, let us hear the lawyer. At least
Yes.
let us hear the lawyer.
Sure,
You are making a serious allegation against a lawyer
of course,
without impleading that lawyer as a party.
because
How is it
though-
possible?
what do you mean, how is it possible?
How is it possible to make an allegation against somebody without bringing him on record?
Your Honor, we have every record.
No,
Every
no,
record that
that's
we
not,
interact
he's
with the
talking
lawyer.
about.
Mister,
Your Honor,
you are trying to act smart.
No, Your Honor.
You are trying to act smart. Where is the name of that person on the record? Okay, we have passed orders.
okay, thank you, Your Honor.
For admission, item number 1.
Yes. Mr. Santi Younger.
Yes, Lordship, I pray for further 2 weeks to file my reply.
Yes,
Lordship.
this is what we find. Mr. Santi Younger, the learned counsel for the petitioner is further granted 3 weeks' time to file affidavit in reply. Okay.
Much obliged. Obliged.
Item number 7.
Lordship, Madam Zakali is the counsel for the petitioner.
Who is for the petitioner?
I am Lordship.
Yes, where is your reply? Ma'am? You have filed your reply.
Yes, Lordship, last order that is on 4/4/24, the last order,
4/4/20.
it has been fixed for hearing and the respondent government was instructed to bring instruction. However, I was informed that there is no instruction, so Lordship,
What is that? What is that order for? Ms. Mosambalana is also granted time to seek instructions on the reply affidavit filed by the petitioner. What instructions required?
that's why it is they who ask. So Lordship, here the records are placed before this honorable court. After the petitioner's application on 10/12/21, they have appointed 24 grade 4 appointments, but I was not considered.
What is your right to the post?
I filed RTI, Lordship, RTI is at page
No, what is your right to the post? You are seeking for appointment.
on compassionate ground, Lordship. My husband, we are the dependents living behind 9 applied after my husband's expiry. On 10/12/2021, I applied for appointment on compassionate ground, Lordship.
What is the stand of the government?
They say that I am at serial number 4. But till 2021, they have not appointed, as per the scheme, they have not appointed even one. So if 3 before me is appointed, they have appointed 24 others. Without 24 others, and if 50% is divided, 12 posts belongs to compassionate appointment as per the scheme, Lordship. So before me is only 3 and 12 posts will be for the compassionate appointment, but they are not adhering to the.
Are you the advocate handling the case?
Yes, Your Lordship.
What reply was required?
Your Lordship, they had filed just a reply to the opposition, which was just the RTI that they filed pursuant to the affidavit in opposition. But since it's a matter of reports, we have no.
On the next date fixed? Mr. So-and-so, learned government advocate. Shall please the instructions. To the affidavit in reply filed by the petitioner and as ordered by this court on 4/4/2024 without fail. Listed after 2 weeks. Okay.
Obliged.
Item number 11 and 12.
Yes.
Lords, in item number 11, the request for de-impleadment was allowed, but unfortunately it is not reflected in the order.
Who is mentioning on behalf of?
Lords, I'm appearing through VC, Lords, in item 11.
Yes. Not visible, that council is not visible. Maybe he's not joined.
Am I audible, Lords?
You are not visible, not audible, not a question of audible, you are not visible.
Lords, am I visible now?
Yes.
Please, my Lords.
What is this here? Sandy Amar?
Lordship, they are he is the contract, they are the contractor, Lordship. Now they have applied for striking off their name from the area of respondents, Lordship. Now I am appearing for the respondents 1, 2, and 3, Lordship, the NHIDCL, Lordship, and the Union of India, Lordship. We have no objections, Lordship, if the IA is allowed, provided the petitioner also has no objections, Lordship.
And you are for?
He is for the respondent number 7, the contractor.
Please, my Lord.
The learned council appearing through VC, he is for?
For the respondent number 7, it says.
The contractor. In fact, Lordship,
This IA is for striking off the name of?
respondent number 7, MS Oasis. Oasis
It was
Private Limited.
the request was allowed last time, but unfortunately, I think inadvertently it was not reflected in the order sheet.
Director of Voices Technicians. You're for respondent number?
1, 2, and 3.
1, 2, and 3. 1, 2, and 3. Four, Mr. MT? 4, 5, and 6. Okay. You're for the petitioner?
I'm for.
No objection from your side?
No objections. I have instructions, verbal instructions, not to object.
Are you okay? Learned counsel for the respondent number 7? Are
Please,
you
my
okay
Lord.
if your name is struck off? Are you
Please, my
okay?
Lord.
Third, Mr. Kringule, learned counsel for the applicant.
Petition,
For the applicant, yes.
not applicant lordship.
You are wrong. This is an application. You should have addressed yourself as applicant.
No, lordship, this application was filed by respondent number 7,
Oh,
not by the petitioner.
you are not, this is not filed by you.
No, lordship.
Oh, you are the applicant here. Respondent number 7 is the applicant.
Please, my lords.
Yes.
Okay. Third, your good name?
J-A-I.
Okay, Mr. So-and-so. The learned counsel for the applicant respondent number 7. You have no objection.
No objection.
Mr. Kringule, the learned counsel for the petitioner. In the main writ petition. Connected writ petition. Mr. Imson, learned counsel for the respondent number 4. And also Mr. Imson, the learned additional advocate general for the respondent number 4, 5, and 6. In the connected writ petition. The applicant / respondent number 7 has filed the application seeking to strike off the name of the respondent number 7 from the area of parties in the connected writ petition number
94/2022, lordship.
94/2022. Mr. Santiago, Mr. Kringule, the learned counsel for the petitioner. Mr. Santiago, the learned counsel for the respondent number
1, 2, and 3, lordship.
1, 2, and 3, and Mr. M. Timson, the learned additional advocate general for the state respondent number 4, 5, and 6. Has no objection for striking out the name of the respondent number 7 from the area of parties. So, the respondent number 7 in the connected writ petition is accordingly struck up from the area of parties.
Much obliged.
Registry to correct the cause title in the connected writ petition. The application stands disposed. Okay. Okay.
Grateful.
Lordship, if I may, in the main writ petition, lordship.
Yes.
The petitioner has approached before this honorable court praying for damage for damaging his RCC under construction RCC building, piggery, terrace cultivation, and approach road, lordship. Now, the contract at that relevant point of time was executed by not by the respondent, the present respondent number 7, who was stricken off, lordship, but by MS Gauhati projects, lordship. So I believe the original contractor, that is the first contractor, lordship, his contract was terminated, but that portion of the road was constructed by him, lordship, the earth cutting. So if I suggest that he shall be a necessary party, I think, lordship, in deciding this matter.
Lordship, at the time when this.
It is not the NHIDCL. You are for the NHIDCL.
I am for the NHIDCL, lordship.
It is not the NHIDCL or the state government who has undertaken the contract. There is some person, some company who has undertaken the contract.
Yes, lordship.
Now, without impleading those person or the company.
Lordship, as we are all aware, that initially that was Gauhati. Then later on that the houses there, which one has been struck off. Then thereafter again, that has been terminated by the respondent number 1 to 3, by the NHIDC level.
So Lordship, now the prayer is against the NHIDC only, and they are working within the scope of the scope of works that was allotted to the contractor. They were just working within the scope of the works that was allotted to the contractors. So if they have any grievance, then let them go against. Otherwise, my prayer is against the NHIDC, Lordship. And Lordship, to update this honorable court, in view of this, after these applications, several joint verification has taken place. Along with all, that means with all this, including the NHIDCL. Then now the proper assessment also done. That also jointly done. And now this joint assessment has been sent to the NHIDCL by the administrations, by the state government. So at this stage again to implead another person, whether that will be reasonable.
Why did you implead the respondent number 7?
Yes,
Because
Lordship.
at that time, a point of time where I filed the instant writ petition, yes, in order to avoid any technical defect of my petitions.
Lordship, I think, again, if you proceed, Lordship, and if the court comes to the conclusion that respondent, the MS Gayatri is a necessary party in the case, then this wasting precious time, Lordship. In fact, I think there is no difficulty in implementing the respondent number 7. And it will also make my job, Lordship, the NHIDCL's job easier, Lordship, more convenient, Lordship.
Yes, Mr. Kekre.
Yes,
I
Lordship.
think you will have to implead that contractor, MS Gayatri. I feel so because actually it was that
Yes.
company which has executed
Yes,
the
the
work.
actual work was performed by them, Lordship.
Then if we go by that, even now also, even the retaining wall is yet to be constructed at that very point of time, that portion, my portion. So in that case, they're not only the first contractor, but the first, second, the third also, because these are collectively again responsible. But my prayer is purely against the NHIDC.
What is the stage?
Lordship, now it's
Yes.
Lordship, here in this matter, in case this matter doesn't end here, then if the matter compelled to be again seek the jurisdiction of the civil court, then there will be a problem. As and when the matter is taken in the other forum, so it's a matter of procedure. So unless the necessary party is completed, and at that penalty stage, that will be a procedural difficulty. So whatever submission given by the NHIDC, it is purely about the procedural matters.
Okay, we'll fix it for hearing.
Lordship.
And if in the course of hearing, it becomes necessary that the MS Gayatri Mitas is a
Yes.
necessary party, then
Lordship.
you implead.
Lordship.
But the government, you are not filing affidavit?
No, we have already filed.
You have filed affidavit?
Yes.
What about Mr. Santi?
I have already filed, Lordship.
Only the state government, they have make all the assessment of the damaged property in lines with the lines department and submitted to the NHIDC. And only at this stage again, they're saying to implead somebody or the procedural part. I think this is not fair. But Lordship, anyway, since I have been pressing since 2000.
Whether the work has been completed on your land?
No.
It has not been completed.
No.
And you are actually like asking for damage compensation.
In fact, Lordship, I have raised preliminary objections, Lordship, on the maintainability. He has an alternative remedy before the civil court, Lordship. He has approached this court by, without approaching the statutory court, Lordship, that is the civil court, Lordship.
matter be heard, the Lordship, and if that is necessary to go before the civil court. Otherwise, see, my prayer also limited here. Limited prayer.
Because question of fact, Lordship, is there, where is very much present, Lordship.
They themselves, they have agreed, they have gone and make assessment. At this stage again saying that disputed question of fact, I do not, we cannot answer. So Lordship, let this matter be posted for hearing. If that is necessary, then that can be.
Any other post? Heard Mr. Kringoli, the learned counsel for the petitioner. Mr. Where is younger Wati?
Lordship, I am representing respondent number 1 as well. Lordship.
Mr. Santi Younger, the learned counsel for the respondent number 1, 2, and 3.
My lord.
And Mr. M. Teamso, the learned additional agent representing the respondent number 4, 5, and 6. It is submitted by the learned counsel for the parties that pleadings are completed and the matter can be listed for hearing. Listed for hearing in the usual course.
Much obliged.
Item number 13.
Bless your lordship.
Yes, Mr.
Your lordship, I'm representing all the state respondents here.
Yes.
I pray that I may be allowed 3 weeks' time to file state contract.
No objections, Lordship.
Mr. Mohamchan, the learned senior governor, 3 weeks' time to file affidavit.
Obliged.
Much obliged.
For orders, item number 17.
Yes, what is?
Well, Lordship, as far as the state, we seek further 3 weeks' time, Lordship, to file affidavit.
May it please your Lordship, in this matter, the private respondent number 4 have not yet appeared before the before this honorable court, your Lordship.
Ms. So-and-so, learned counsel for the petitioner, and Mr. So-and-so, learned government advocate for the state respondents. The learned state government advocate seeks for 3 weeks' time to file affidavit in opposition. Office note dated 29/2/2024 shows that return service report in respect of respondent number 4 is awaited. Listed after 4 weeks. Okay.
Much obliged.
For hearing, item number 19.
Yes, what is the case?
Lordship, this more or less the facts.
If it is a lengthy matter, this court may not be able to take up. This court is already loaded with files. Yes, what is the case?
If your Lordship may go through this section which was
Let's
discussed earlier, your Lordship. Facts are more or less same.
Facts are more or less same with what?
With this case, with the instant case, it is related to the same duct, same plot of land. This honorable court has held that the deputy commissioner has no power to cancel the before entering into the facts, your Lordship. The most important issue has been decided in this case.
The question is whether Purana Bazar B is a cadastral land.
Your Lordship,
If it is a cadastral
no,
land.
it is village land. It is not. In the Village and Village Council Act, Your Lordship, it is very clear. Even if it is the government has land only in Dimapur. Now the Village Council Act makes it very clear that
Purana Bazar B is a Kachari's land, which has
Your
been
Lordship.
inherited by Nagas either way by purchase.
Your Lordship, but then it has to go by the law.
No, I know the
Statute,
law
statute,
on
yes.
that.
Your Lordship knows the law very well. So.
But Purana Bazar B is a cadastral land.
Your Lordship.
That is why
it
all the
falls under-
allotments are being given pata.
Your Lordship, but if Your Lordship may allow me to take Your Lordship to the Village Council Act, the Village Council Act makes it very clear. The village land, the village land, what constitutes the village land? Even land given to the village by the government. And the map is very clear. The map, in the map itself, the land falls within the, inside the village.
Mr. Tongkok, are you aware of the fact that in Dimapur, there is cadastral village, non-cadastral village?
I know. Your Lordship.
And if your land falls under the cadastral village, it is a surveyed village.
Your Lordship, the judgment also is very clear. It is a village established in 1942. It is a village established in 1942. The land, the village. And the village council.
I believe even the village council chairman is having a pata land.
Your Lordship, yes, but the Village Council Act covers this.
If
land.
it
we
is- if
go
it is-
into all those areas where the law is not.
If it is a non-cadastral land, law we know, village council act we know.
Once, yes.
But actually you should actually differentiate between a cadastral village, non-cadastral village. If it is a cadastral village, the village council has no right or authority to allot the land. That's the issue.
Your Lordship, if it is a established village council, the Village Council Act makes no distinction between non-cadastral and cadastral village. Village Council makes no distinction, the act. If we have to make a distinction between cadastral village and non-cadastral village, when the Village Council Act makes no distinction, then it would
See,
be. Your Lordship.
for example,
Yes.
I also live in a village
Your Lordship.
in Dimapur.
Your Lordship.
It is the cadastral village.
Your Lordship.
Even the chairman, the head GBA has been allotted pata by the government.
Your Lordship, the judgment is also very clear. It clearly.
We may refer it to a larger bench. If I'm in disagreement with this,
Your Lordship, in that case, I leave it to your Lordship. I leave it to your Lordship.
because
Yes.
if suppose we actually say that actually Purana Bazar B is a village constituted under the Nagaland Village Council Act
Yes.
and the land belongs to the village,
Yes.
there'll be chaos. There'll be chaos.
Your Lordship.
That means the village council will start allotting land with their own pata, overlapping the pata issued by the government. And there'll be chaos.
Your Lordship, but in the absence of any.
That we can foresee.
Yes, but in the absence of any statute saying that cadastral land and non-cadastral village and cadastral.
No,
village-
it's a surveyed land. It's a surveyed
Your
land.
Lordship, it is, but the Village Council Act applies in this case. Your Lordship.
But no, it's a surveyed land. Village council
Yes.
act for the functioning of the village, okay. But insofar as the land is concerned, it's a surveyed land.
Government land given to the village, according to the Village Council Act.
No. Where is that order which, by which the government has given land to the village?
Your Lordship, it is very clear, Your Lordship, the Village.
Village
Act-
Council Act is for enabling the village council accordance with that law.
Yes, but then it also gives the village, at the very complete portion. it also
Mr.
gives
Tom
the-
Pok, you
Your
want to invite a bomb of litigation.
Your Lordship, if Your Lordship may go through this, go through the Village Council Act and then see the.
I know the village council.
Yes, Your Lordship.
Village
but
council
whenever
should
it-
function as per that.
Yes.
Village council should function as per that. And so far as land is concerned, insofar as traditional village is concerned, that is a different issue. Insofar as surveyed villages like in Dimapur is concerned, the village council has no authority to allot land.
It is a traditional village, Your Lordship. As per the government,
The name itself suggests that it is not a traditional village. Traditional village means a Naga traditional village.
Your Lordship, traditional village, according to the government finding. According to the state government finding, it is a traditional village. Now, when the government itself is saying that it is a traditionally established village. and then we start
Mr.
making
Tongpo,
distinctions.
I will have differences of opinion with you because when I say village, okay, let us accept that it is a recognized village. Recognized village to function, to carry out the functions of the government in the village.
Your Lordship.
But it is a surveyed land. So when the government has allotted land to each and every individual, including your chairman of the village council, including your head GB.
Your Lordship.
Now suppose if the village starts allotting land on the ground that this is a village land, will it not overlap the allotment made by the government, thereby bringing a multiplicity of litigations?
Your Lordship, unless we go by the law, when the law, if we should go by other aspects, when the law is making it very clear, then.
The law, Village Council Act,
The statute.
Village Council Act,
Yes.
Village Council Act, that section 14 or something for the village authority to deal with the land has already been deleted.
No, it's.
Has
still
been
there.
deleted.
It is still there. Your Lordship.
No, it has been deleted. The Village Council Act, empowering the village council to deal with immovable properties has been deleted. Has been deleted.
Your Lordship, it is still in the statute books. Then secondly.
No, it is there in the statute book. It has been
Yes.
deleted. You see the different editions.
Your Lordship,
But Mr. Tongpok, I cannot give you the land.
Your Lordship, it is. Your
You approach the civil court. If you feel that you have a land, you have a right over the land.
Your Lordship, consider it in the light of the judgment of this, of this honorable court. In the light of this honorable court. Secondly, in the light of the Village Council Act, it is also mentioned in the Village Council Act is mentioned in the act. And then the Village Council, if your Lordship will allow.
I
me
am
to-
not agreeable to this judgment. If I am not agreeable, I will refer it to a larger bench.
Your Lordship, then in that case, it may be referred to a larger
Hmm.
bench. Because now the coordinate bench has already given a decision. It is already there. Secondly, the Village Council Act also makes it very clear, Your Lordship. If your Lordship may.
Why has the government not challenged this?
May only allow me.
Why has the government not challenged this?
Lordship, yes. However, your Lordship, in this matter, if I may be allowed to read just one para in the writ petition, Lordship, things will be clear. Lordship, para 2, clause 3, wherein the petitioner has stated, if I may be allowed to read this para, your Lordship, it says that the Nagaland Village and Tribal Council Act 1978 clearly lays down in the explanation to section 3 as follows. Now the section 3 is incorporated here. Then the village means an included area recognized as a village as such by the government of Nagaland. An area in order to be a village under this act shall fulfill the following conditions, namely, A, the land in the area belongs to the population of the area or given to them by the government of Nagaland if the land in question is a government land or given to them by a lawful owner of the land. And B, the village is established according to the usage and customary practices of the population of that area. Your Lordship, next line. The act does make it clear that the land in the area belongs to the people of the village. This being the legal position, the land that is dark number 104, that is the land in question, Your Lordship, which is entirely situated within the Purna Bazar B village, undoubtedly belongs to the Purna Bazar B village. No doubt, the Purna Bazar B village falls under cadastral area. So it is a cadastral village. The petitioner himself is admitting it.
Mr. Tongpo,
Your Lordship.
Mr. Tongpo,
Yes, yes.
kindly justify why the dark number 104.
Yes.
Why? What dark number 104 signifies? What dark 104 signifies?
Yes, Your Lordship. I am not disputing that it falls within the cadastral area, Your Lordship. There is no dispute.
So you want to allot the land?
But now, the village itself, it has been given the land under the Nagaland Village Council Act. When there is no other law in existence, which says that.
Mr.
This is
Tompok,
this is not covered by the. village council Act.
you are not well conversant with the land holding system in Dimapur.
Your Lordship,
That is
I.
why Doug number 104 has been given. Why Doug number, what signifies, what it signifies?
I know, Your Lordship, because
It signifies that it is a cadastral land already
it
surveyed.
falls under surveyed area, Your Lordship. Then this is not disputed, Your Lordship. But if Your Lordship is not agreeable with the judgment of this honorable, the coordinate bench of this honorable court, then let us refer to a higher bench for decision. So that on the basis of the law available, it can be decided by a larger bench.
Well, we will also direct the court to place this record of WPC for 4090. We will also see the facts.
Yes, the facts are-
But if
facts
it
are
is
very-
before me,
Yes, Your
I am
Lordship.
not agreeable to your submission. If it
The
is before
facts-
me.
Same
But-
facts. Your
But I
Lordship.
want to actually like satisfy myself with the facts.
Yes.
Because village council, just there, it is obvious that the village council has no right or authority to allot land. And that is your case. You want to allot land overlapping the allotment made by the government? That's not possible. You will invite problem.
Your Lordship, if this honorable court should go outside the boundaries of. the
I am
law,
not going outside the boundary. I am not, mind you, I am not going outside the boundary. I can foresee what trouble lies ahead if the village council is allowed the authority to allot land overlapping the government's allotment. I can foresee. And that is what you are seeking in your writ petition.
Your Lordship, because the law says so, Your Lordship, because the law says so.
I heard Mr. Tompok Pomoner, learned counsel for the petitioner, Mr. So-and-so, and Angami, learned government advocate, learned Mr. N. Angami,
For
learned
respondent one,
senior government advocate for
Yeah.
the respondent number
1, 2, and 3, my lord.
1, 2, and 3, and Mr. P.P. Paul, learned counsel for the respondent number 4. Stop. On the next date fix, the case record of WPC 40/2019 shall be placed along with the present writ petition listed after 3 weeks.
Lordship, the interim mechanism.
The interim order passed earlier shall continue till the next returnable date. Okay. Okay.
Obliged, my lord.
Item number 24.
Yes, what is the case?
Sorry, Lordship. Lordship, matter pertains to commissioner appointment. The petitioner as well as the proper respondents, both are claiming for commissioner appointment, Lordship. The petitioner is senior to the proper respondents. However, Lordship, without considering the case of the petitioner, the proper respondents was appointed on commissioner ground.
We will list it some other time. Okay, list it after 2 weeks.
What's it, a date maybe fix, a short time? Because there's a long pending case also. Short time and a date may fix.
List it on 29/5/20, sorry, 28/5/2024.
Okay.
28 years.
Item number 25.
None appears for the parties. Listed after 4 weeks.
Item number 28.
Is for the parties listed after 4 weeks.
Item number 29.
Lordship,
Yes.
as directed by on the court, some record the judgment. Passing the PC number 286 of 2022, Lordship. Lordship, the matter relates a bit different, Lordship, because the petitioners there, they were working under the mission, Ayush mission.
Okay.
So in 2019, 8 posts were created for them. In this case, the one I'm placing, Lordship. 8 posts were created for them. So there were 10 of them, senior most, who have served for more than 15, 16 years, 17 years or so. So 2 resultant vacancy was taken out and the committee was constituted to absorb them from the Ayush mission to the state cadre. During that time, COVID came. Now, during COVID, 11 posts were created. So because of the exigency of service, Lordship, 11 post creation during COVID plus 10, 21 were advertised. The petitioners also participated in the selection. They got selected. Now, when the impugned 2nd November 2022, the notification which is under challenge in the present writ petition, that was also challenged in this writ petition. So the Honorable Court has made a clear distinction that posts created during COVID should go along with SRD. But as far as the 10 posts which was held by the petitioner, the matter was left to the government to decide whether to go for absorption as per the government committee decision or through recruitment. So
10 posts, that is
earlier to COVID. Earlier to COVID.
And the 11 posts?
Is COVID post creation. Lordship, I was showing the Lordship yesterday, the post creation in my affidavit, because my affidavit itself will, Lordship, explain. The petitioners are in fact aggrieved. Their case is based on this, but they have not annexed the documents.
Which is that case?
Lordship, may kindly come to my affidavit of respondent number 2 and 3, Lordship.
Respondent, yes.
Page 12, annexure A.
Page 12.
Yes. This is the memorandum issued on 25th June 2020. This was during the COVID, Lordship. Agenda number 1, recruitment of doctors, nurses, and other paramedical staff in the Health and Family Welfare Department.
You are reading which? Recruitment of doctors, nurses?
Yes, Lordship. And other paramedical.
This is 2020.
Yes.
2020.
During COVID. This memorandum was, the matter was placed before cabinet, Lordship.
Correct.
4. Creation of 3 posts of junior dental surgeon in CHC. So this is the post concerned here in the present case, in the present writ petition. And the judgment that I placed, Lordship, is concerning item number 3, creation of 11 posts of Ayush medical officer. So, Lordship, I'm trying to make a comparison. In case of Ayush, it was 11 post creation, Lordship. In case of junior dental surgeon, 3. Now, Lordship, the terms and conditions laid down by the cabinet. Lordship, I kindly come to page 13 again. Lordship has found the cabinet further directs that A, all the newly created posts, Lordship, this is very important, all the newly created posts should be filled up by the Health and Family Welfare Department within a month's time with proper advertisement. While filling up the post, due weightage should be given to the marks obtained by the candidate in the qualifying degree of the university, medical college, and years of work experience. The interview panel should include independent experts from outside the state. B, this is very important. The department should clearly indicate that this appointment will be temporary and regular recruitment shall be conducted through special recruitment track. So A and B should be co-jointly read. They should not be read in isolation. So the post creation is 3.
So this 3 posts of junior dental doctors
were created.
Were created to be recruited through special recruitment drive.
Yes, later. Initially through temporary. Now, Lordship, coming to the next annexure B, page 14. This is the notification issued by the department, creation of the post, Lordship. Lordship, may kindly come to serial number 4. In the interest of the notifications reads, Lordship, in the interest of public service, the Governor of Nagaland is pleased to order the creation of various categories of posts under the Health and Family Welfare Department. Serial number 4, Junior Dental Surgeon. 3. Lordship has found. So this post notification of 3 post creation is that memorandum of 25th June. So 3 posts were created. Now, Lordship, may kindly come to the next annexure C, page 15. Since it was going to be a temporary recruitment, Lordship, the service rule was not to be followed because it was pandemic, Lordship. So a guideline was issued by the government on how the recruitment should be done. So this is the guideline, Lordship. He also mentioned about—
What is the issue now? You
Now-
were saying that you were in agreement.
No, not in agreement.
No, in agreement that this 3 posts will be as per the special recruitment drive, 2 posts as per the service rules.
Yes, not in agreement, Lordship. My
If
case
you are
is—
not in agreement, we will hear both the parties.
No, Lordship. What I'm trying to say is, Lordship, here, they are saying that all the 5 posts should be through open recruitment.
No,
This-
yesterday, Mr. MT, he was in agreement.
Yes, Lordship. Yes, Lordship. I have challenged
You have challenged all the posts should be as per the service rules.
all
Advertised as per the
service rules, but now.
But yesterday you were
the
making a
is-
submission that 3
Yes.
posts, which was created during the COVID, it will be through special recruitment drive and 2 posts as per the advertisement, as per the service rules.
Yes.
Yes, that was what yesterday,
Yes,
that's why it was fixed.
So, Lordship, my humble submission, Lordship, not in agreement with the petitioner, Lordship, but what I'm trying to do is I'm trying to bring the picture before this court. This is actually what has happened.
No, I know the picture very well.
Yes, Lordship.
I've spent my days writing judgment on this.
Lordship. Appreciating your Lordship, yes, concern on that. Now, the impugn notification that is under challenge, the post added is 5.
2.
So 2 should be taken out. That is the issue, Lordship. Because what the petitioners are asking, Lordship, is with regard to 2 only.
So let the department make correction with the correction, with the notification.
Yes, Lordship. Now, basing on the judgment that I have placed just now, Lordship. So that is also there.
We will leave aside this judgment.
Lordship.
We will leave aside this judgment.
Lordship.
But if we are to actually agree to the submissions made by the council for the parties,
Yes, Lordship.
then we'll give a direction to the state respondents
Yes, Lordship.
to modify the notification.
Yes, as far as the dental surgeon is concerned. Yes. So in fact, Lordship, my affidavit is on that line only. I pointed out, Lordship, may kindly appreciate my affidavit at page number 2. Page number 2, paragraph 3. Lordship, as I've already pointed out yesterday also. The relevant portion will come from page 3, Lordship, the next page, the subparagraph, as stated above. I have clearly stated here in my affidavit that the post creation is 3 only during COVID. So the 3 posts should not be disturbed as far as the special recruitment drive is concerned. That is my humble submission. Now the next paragraph, Lordship, on the same page, the last paragraph. Thereafter, in view of the cabinet decision, 3 posts of dental surgeon, along with 2 resultant vacancy, Lordship. I've clearly stated in my affidavit.
Along with?
2 resultant vacancy. The last paragraph, Lordship. In the same page.
So let the resultant vacancy be advertised as per the rules.
Yes, as per the rules, Lordship. Lordship, in fact, my affidavit speaks, Lordship. The last paragraph. I've clearly stated 2 resultant vacancy. 3 post creation along with 2 resultant vacancy were advertised.
Yes, Mr. MT, what is your?
Yes, Lordship. Lordship. May I, Lordship?
Yes.
Lordship, yes, we have, in the writ petition, we have challenged that all the 5 posts should be advertised through advertised in accordance with the service rules and not in accordance with the method prescribed by the impute notification. However, Lordship, during the course of hearing, and my clients have also been asked by the directorate to go that they will only insist on 3 posts which were created during the COVID for the special recruitment drive, and all the other remaining posts will be advertised in accordance with the services, will be filled in accordance with the service rules. So, Lordship, I also agree, and let the special recruitment drive be confined only to the 3 posts which were created during the COVID, Lordship. And all the other posts should be filled up strictly in accordance with the service rules. That will be fair, Lordship.
Yes.
Yes.
Not Mr. Imti Longjam, Learned Counsel for the petitioner. We didn't bring a Trevisi.
I'm representing the respondent number 1, that is the State Chief Secretary.
Mr. Moya Imchen, the Learned Senior Government Advocate for the respondent number. Are you also in agreement?
I'm in agreement.
Also respondent for the respondent number 1, and Mr. N. Muzui, Learned Counsel for the respondent number 2 and 3.
Lordship.
We pass the order.
Lordship. Obliged, Lordship.
So it'll be on the line.
Lordship.
3 through
Lordship.
special recruitment drive, 2 strictly as per the service rules, to be advertised strictly as per the service rules.
Yes.
Mr. MT,
Lordship,
are you in agreement?
Lordship, yes.
We
Yes,
are going to
Lordship,
pass the consensus order.
this special Lordship, any other post except for the new post created for the COVID, only that should be through the special recruitment drive. All other posts through the service rules, Lordship. Because there are some other vacancies also pending. 8 vacancies, I'm told. Altogether 10 vacancies. So resultant vacancies.
Dental surgeon?
Yes,
Dental
Malak.
surgeon?
10 resultant vacancies.
Lordship, that since we are confined to only 5 posts now, so Lordship may kindly, because other posts will be definitely as per the service rule, but the issue involved is 5 posts. So 3 as per SRD and 2 as per the rules. Lordship.
Okay. We write all this.
Yes. Obliged, Lord.
Yes.
Obliged, Malak. Vicky masih. Complicated. Hello. 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 Bye-bye.
Bye.
Bye-bye.